Hey everyone, hope you are doing well and happy. So in today's video, we're going to understand the difference between Supreme Court and High Court power. So the court has been understood as the guardian of fundamental rights. So in this video only, we will understand how they are empowered to protect the rights of the citizens. So let's move into the very first slide. Let us first know enforcement of fundamental rights under the Indian Constitution. So we all are very much aware of that we all are vested with certain fundamental rights. But what if they get violated? If there is no remedy available, there is no point attaching the fundamental right into the very Constitution. So in today's video, we are going to understand what are the remedies that is available in order to enforcement of the fundamental rights. The Indian Constitution not only provides fundamental rights but they can be en- also ensures they can be enforced. So this is talking about the remedies of fundamental rights. Article 32 gives the Supreme Court the power to protect these rights. So Article 32 has given power to the Supreme Court to protect the individuals or citizens' rights. It also allows Parliament to give similar powers to other courts. So along with the Supreme Court, the Article 30 also allows Parliament to give similar power to other courts. People can directly approach the Supreme Court if their fundamental rights are violated. So under Article 32, if any person's fundamental rights have been violated, they can approach the court for enforcing it. In fact, the right to go to court for this purpose is itself a fundamental right. So the right to go to court will also fall under Article 32. Also, Article 32 gives power to the person or gives power to the Supreme Court to enforce the fundamental rights of citizens. Article remedies under Article 30. As I say, Article 32 works as a remedy of the Indian Constitution. Article 32 provides the following remedies to protect fundamental rights. So all the remedies have given here in a pointed format. So I'll be reading this first, then I'll try to discuss it. Every person has the right to approach the Supreme Court through proper legal proceedings to enforce their fundamental rights. This includes using the Supreme Court's power to issue writ. So anyone can approach court if their fundamental rights have been violated, and this includes using the Supreme Court's power to issue writs. So writs, which is also a very important topic under the Constitution, will follow under Article 32 only. The Supreme Court can issue various orders or writs like habeas corpus, mandamus, prohibition, quo warranto, and certiorari. As I said, we have 5 writs in total, and they have different kind of nature. So based on the nature of that case, writs will be applied. Parliament can allow other courts to use the same power as the Supreme Court for enforcing fundamental rights within their area of authority. As I said, just like Supreme Court, Parliament also authorized to give certain similar kind of powers to other court as well. The right to move the Supreme Court under 32 cannot be suspended except in situation mentioned in the Constitution like during an emergency. As I said, Article 32 has given us the power to approach a court, but if there is an emergency, then that can be suspended, and it is a limitation on Article 32 under Indian Constitution. Now let us know about the powers of High Court under Article 226. The Article 226 also a remedy for, for enforcing of fundamental rights. Article 226 says that even though Article 32 gives power to the Supreme Court, every High Court also has the authority to protect fundamental rights. This means the Supreme Court and High Court share similar kind of powers regarding this manner. High Court can issue directions, orders, or writs such as habeas corpus, mandamus, prohibition, warranto, and certiorari. As I said, there are 5 writs that is available, and the High Court and the Supreme Court can use the writs to any person or authority, including the government, within their area. So they can be used against any person or any authority or any government within their located area. These powers can be used not only to enforce fundamental rights but also for other legal purposes. So these can be used either the person's fundamental right has been violated or there is any other legal purposes. So for both the reasons, Article 32 and 226 can be used, or the writs can be used. High Court's power do not reduce Supreme Court powers. Now there is the dilemma that if the High Court is exercising the power given to the Supreme Court, will it lessen the powers given to the Supreme Court? So in this manner, Article 226 Clause 2 has been clarified it. According to Article 226, the powers given to High Courts under 226 Clause 1 do not take away or lessen the powers of the Supreme Court under Article 32 Clause 2. So it has been made it very clear under Article 226 Clause 2 and 32 Clause 2 that just because High Court is exercising the same power just like Supreme Court, they will not decrease the power vested upon Supreme Court. Both courts can protect fundamental rights, and the High Court's powers do not interfere with the Supreme Court's authority. So both the courts has been vested with the same power, and they are authorized to protect the citizens' fundamental rights, and they are not interfering in any other's authority. Now let us know the very concept of what curative petition is. A special review by the Supreme Court. So curative petition is a special review given by Supreme Court. So we will understand it through a case law. In the case of Rupa Ashok Hura versus Ashok Hura 2002, the Supreme Court said that it can review its final decision to correct a serious injustice even after a regular review petition has been rejected. This special type of petition is called a curative petition. So if a judgment has been already made, but the petitioner felt that there is some kind of injustice or the violation of natural justice, by using the curative petition, the Supreme Court can re-review the decision given by Himalaya. However, the court set some strict condition for filing a curative petition, but in order to doing so, the petitioner has to meet certain kind of conditions. The petitioner must prove that there was a violation of natural justice. For example, if they were not given a fair hearing. So fair hearing is an element of natural justice. So the petitioner must have to show that to the court that his natural justice has been violated. That is, he didn't got the chance of fair hearing. The petitioner must include a certificate from a senior lawyer confirming that these conditions are met. So in order to have a witness, the petitioner has to include a certificate from a senior lawyer by saying that the above condition has been met. If these rules are not followed, the court may punish the petitioner by making them pay exemplary costs. So, if the court feels that the above mentioned criteria is not exercised, they may punish the petitioner for wasting the court's valuable time. Now let us know about some of the limitation on the enforcement of fundamental rights, which I have already given a hint in my earlier slide. The enforcement of fundamental right is subject to certain limitations, especially during emergencies or in relation to the armed forces. As we all know, during the emergencies, many articles got suspended, and in that time, no one has the right to visit court for the enforcement of fundamental rights. So now in this slide, we will understand what are the articles that impose certain kind of limitation on the enforcement of fundamental rights. Article 33. So Article 33 is a limitation on the enforcement of fundamental rights. It talks about Parliament can make laws to limit or cancel fundamental rights for members of the armed forces or force responsible for maintaining public order. This is to ensure discipline and proper performance of their duties. So Article 33 is an limitation. Then we got Article 34, which talks about if martial law is in force in any area, Parliament can make laws to protect people from legal action for acts done during that time. Even though acts violated fundamental right, this includes validating punishment or action taken under martial law. So it is relating to martial law. This is also a limitation on the enforcement of fundamental rights. Now we have Article 359, which talks about national emergency. During a national emergency, the president can suspend the right to go to court enforce to enforce most fundamental rights except Article 20 and 21. So during Article 359, the president has the power to suspend the right to go to court, but it cannot suspend the Article 20 and 21. So this is also an limitation. The suspension can apply across India or in specific areas thus as long as the emergency or for a short period stated in the order. So as long as the emergency occurs, this will continue. Then we have Article 350. While an emergency is in force, the government can make laws or take action that may violate the freedoms guaranteed under Article 19, like freedom of speech or assembly, and such action challenge cannot be challenged during that period. So we all know if any emergency like situation happened, the right to gather, the right to give speech, all this has been suspended, and this is the very power given to the parliament under Article 50, which talks about the emergency situation. So these are the very article which talks about the limitation or imposement on the enforcement of fundamental rights. Article 33, 34, 359 and 358. So this is all about how Supreme Court and High Court works, what are the important writs and what are they, what is curative petition. So all the information I try to explore through this video only. If you want to get updated with such more legal concepts, like, share and follow for more. Thank you for watching the video.